Hi there, it's Chris here from the Hampstead Property Blog. Now in today's episode I'd like to talk to you about what is happening in the ever-growing private rented sector. Now all kinds of situations will arise over time, and today I'd like to talk to would-be landlords and existing landlords about what to do if your tenant suddenly does a runner and just disappears off the face of the earth. Now, in the main, tenancies are conducted without much disruption and with the usual processes and procedures in place. There will be a checkout meeting at the end, and keys will normally be handed back to the landlord or his agent or even the inventory clerk. Now, on the odd occasion, you may find that your tenant has just disappeared. What do? Do you just re-enter the place, get it cleaned up and get it re-let? Well, yes and no. Many landlords act instinctively in these situations and go with their gut feeling. The typical thing is to change the locks, though this puts you on the wrong side of the law in most cases, and your actions could result in an unlawful eviction case being brought against you. You could get hit from both sides here, as firstly, the local authority can prosecute you, and secondly, if the tenant has reappeared just out of the blue, he or she could sue you for compensation. Now, if you've had reason to believe that the tenant had actually vacated, then this is your one line of defence. Though in situations like this, and for the sake of covering your own back, best practice is to leave an abandonment notice on the front door just to save any comebacks. Now, the only drawback with this is if there was some kind of an unforeseen situation concerning your tenant. Perhaps there was a serious car accident that they might have been involved in, and ended up being in intensive care in a hospital for 2 weeks, or maybe even the sudden passing of a close relative. Both of these things would suggest that your tenant may not have seen the notice. Now, as this is a civil matter, in law there is a concept of what is known as implied surrender. Now this means that if the tenant's actions were not consistent with vacating in the usual way, as a landlord you can accept the offer to vacate the property and go in and change those locks. The question is, how will you know when this rule will apply? Now, here are some different scenarios that you've got to be aware of. Firstly, has the tenant indicated that he or she will leave by a certain date? Now, if the tenant, for example, has told you in April that he's going to be leaving in June, and there was no further contact from that point on, and you visited the property, say, a month later in July, and saw there was no one there, I think it's a fair assumption that your tenant has left. This, however, may be subject to the following. Firstly, double check to see if any keys have been left behind. This is normally the most important sign. If keys have been left in the property, then it also suggests that possession has been given up. The other point to remember is, are there any possessions left behind? If you don't see any sign of any personal possessions left in the property, then it would also be fair to assume that the tenant has given up possession of the place, especially if the keys have also just been found in the property. Now, in instances that you find the tenant's possessions remain in the property, then it may be wise to take a cautious approach and apply for a possession order from the court. Now, finally, are there any rent arrears? Unless you can see that the tenant has clearly moved out, don't go for possession of the property if you have been receiving rent and all the payments are actually up to date. If the tenant wants to leave the property empty, then ultimately it's their prerogative. Now, if on the other hand there are arrears and you find the place empty and the keys left behind, then I think it's safe to proceed with getting the place ready for reletting. It will also make it safer for you to repossess if the tenant was to make any claim against you for any illegal eviction. So therefore any award that he might get would be offset against any rent arrears that you might be looking to claim. Again, it pays to be cautious, as tenants are entitled to occupy the property whilst they are in arrears and until such times they're evicted by a court order. Now, a final thought. If you have used an agent to rent your property or you've let it yourself, it's always worth having details of your tenant's next of kin as a point of contact, as in such a situation this sort of information may prove to come very handy. It's also been known for dishonest tenants to make it look as if they've moved out to entice you as the landlord to gain possession and then try to sue later on and be compensated for unlawful eviction. So there it is, these are the pitfalls. I hope that the information here has been some use to you in this episode and that you've enjoyed listening in. Thanks again for watching and speak to you again soon. Bye for now.